I mean, it depends on how the jury's going to accept the facts that this child had been problematic before, that there had been a warning that was given. And certainly, if you were to take the oddity of this out, that is more warning and negligence by not responding to it than you would get in a car accident that just happens and you don't have any opportunity to respond to it. So I think the plaintiffs are going to hammer the fact that it doesn't have to be a conscious thing. In this particular case, it was a conscious act. It was a decision not to act when they were given forewarning. So it seems pretty foreseeable to me that injury could result from their failure to act.
It's that failure to act and the gun and the parent wasn't there. Now, we know that the mother faced criminal charges. We know that Dr. Parker faces criminal charges. And if she were to testify in this, I think she'd have to, claim the Fifth Amendment right not to incriminate herself because she doesn't want it used against her in the criminal charge. The judge didn't buy that argument and said, civil trial, you're going first, let's go. How does that affect this trial, though? Can she put up a full defense when she may not really be able to testify?
This is a problem we have in, I don't know, a solid amount of cases, 30% or more, where even in my own practice, where I have somebody charged with a crime and there's a civil component to it, the last thing that I want to have happen is have my witness on the witness stand in a civil, or my client on the stand in a civil proceeding where the government, the prosecutors who are otherwise not entitled to their statements are lying in wait, like I did as a prosecutor, salivating at the civil case, hoping that the defendant is going to be forced to answer interrogatories or depositions or testify, and therefore I'm getting information that I otherwise would not be entitled to. But it puts the defendant in a very, very difficult position to judge, what do you value more, your liberty or your finances?
Mm-hmm. Yeah, and again, I think she's covered by insurance in this case, by the organization that represents teachers. So she may feel like she needs to, because I can tell you what, Bob, in my estimation, she needs to tell her story.
Yeah, I mean, the axiom, you know as well as I do, Michael, the axiom of any criminal defense lawyer is you don't want the person on the stand. And to the extent that insurance covers things or doesn't cover things, I mean, I'd be very uncomfortable if I were her lawyer about that, because sometimes it covers unless there's a determination made that the conduct was purposeful or knowing or was absolutely reckless, in which time they may decide to not cover. In fact, many times when somebody commits a crime, insurance companies say, hey, wait a second, we're here for negligence, but we're not here for purposeful criminal activity here. So she's, I think, on the spot from an insurance perspective as well, even if she claims she has coverage.
Yeah.
That's something that's going to be battled out by the lawyers down the road.
Right.